Good day, Crime Talk aficionados. We have a great show for you today. First, another interlocutory appeal in the Richard Allen Delphi homicide case. The Tryreek Hill bodycam video has been released. Should Mr. Hill have simply complied, or did the officers overreact? This is what vigilante justice can get you. Prison time. A police dog dies. His handler is charged with the dog's death. This day in legal history, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can listen to us anytime on any of your favorite podcasting apps. Quick programming note. We will not be doing our live show tonight. We'll be doing it tomorrow night, same time, 6 p.m. Mountain Time. So please join us on a special night, Wednesday. All right. Before we get to the docket today, let me ask you to go to CrimeTalkSearch.com. Sign up for that background subscription service today. And when you do, you can do as many background checks on anyone you like here in the United States as your little heart desires. All right. And you're going to get information as to whether these individuals, are they married? Are they divorced? Have they been to prison? Do they have a criminal history? Are they on one of those public lists that they have to register for because of some inappropriate conduct? Those are the type of things you're going to find out. Do they own property? Are they living in their mom's basement? You'll be able to tell. And here's the beautiful thing. You can do as many searches as you like, and you can stop maybe after one search, or you can keep it and do it for anyone who is coming into your life. What about those parents of children that are hanging out with your kids? What do we know about them? Check them out. CrimeTalkSearch.com. All right, let's go ahead and begin today's docket. First, a couple of things I want to talk about. A couple of things. We talked about the Atlanta, Georgia school shooter case the other day, and a lot of people are like, "Oh, Scott, we disagree with you. Parents should be charged anytime they have a juvenile that commits crime." So I say, by God, let's do it. Anytime anyone over the age of 10, which is the age where most kids can be prosecuted, anytime a child over the age of 10 commits a crime, let's charge the parents. And let's not forget those crazy high school years, right? Let's charge the parents as well. All right, becoming a bad parent, well, it should be criminal, according to what most people say. Or maybe there's just an exception for the school shooting type of case. Like I said, it's one thing if dad was said, "Hey, today's the big day, kid. We're going to go down there. We're going to do what we talked about. The big plan's coming together." Then we should obviously charge that parent. But if they didn't know that is going to take place, they shouldn't be charged. And a negligence standard is a very scary thing in criminal defense, ladies and gentlemen. A criminal defense reasonable person standard is that it's reasonably foreseeable, right? That's what we use in tort cases. Was it reasonably foreseeable if you didn't leave enough distance between the car in front of you that if you had to brake, you could hit them? Reasonably foreseeable. That's it. Anything's reasonably foreseeable looking back, hindsight 2020, ladies and gentlemen. I say charge them all. Why stop there? Why stop when people turn 18? Obviously, if people commit crime over the age of 18, their parents were probably responsible for it because they were bad parents. Let's just criminalize being a parent, ladies and gentlemen. Just something to think about. Remember when those prosecutors said the Crumley case was a unique legal theory in which they were now prosecuting people? I told you, it's coming to a district attorney's office near you. Now it's in Georgia. Wait till they come for you or your friend or your family member, ladies and gentlemen. Crime has always been about what the individual knowingly did. Can you imagine being held responsible for somebody said, "Well, you knew or you should have known what was going to go on. You should have known." That's really what they're saying. If you knew that they were going to go do it, then you could be held responsible. Not you should have known. You could have prevented it, but you didn't. Scary path. Ladies and gentlemen, scary, scary, scary. All right, let's go ahead and get to the docket for September 10th, 2024. Now, this latest appeal could jeopardize the October start date for the Delphi murder trial. Why? Because Richard Allen's defense team has signaled that they are going to file or have filed with the Indiana Court of Appeals to overturn Special Judge Francis C. Gull's decision, barring the defense for Richard Allen from presenting its Odinism theory in court. Now, the filings by Allen's defense have moved forward with a rare interlocutory appeal challenging the decision to not let them present alternative killing theory during that trial. Now, the appeal request was filed in response to Judge Gull's handing down a decision back on September 4th, which granted most of the state's motion in limine, looking to prevent the Odinism alternative theory in the court proceedings. Now, the defense contends that the court's September 4th, 2024 order denied Richard Allen's right to present a defense in violation of his Sixth Amendment rights that he possesses under the United States Constitution, as well as the applicable provisions under the Indiana State Constitution. Now, for those who don't know or don't recall, Allen's been charged with 4 counts of murder for the alleged role in the February 2017 deaths of Abby Williams and Libby German near the Monon High Bridge back in Delphi, Indiana. Now, Allen has been in custody since his October 22 arrest, when he was arrested by the Indiana State Police. Now, this is the latest turn in the legal battle involving the defense attorneys and Judge Gull, the prosecutors as well. And a large component of the contention has centered on Allen's lawyers arguing that a group of Odinists were responsible for the killing of the girls instead of Allen. Now, the defense challenged various affidavits in a Franks hearing, saying that there were omissions that were kept from being presented to the judge, and if the judge was aware of that, they never would have granted the arrest warrants and or search warrants in the case. Needless to say, the judge has denied all of those motions like she has for everything in the defense case. Now, the cult theory of Odinism has featured a focus on various people that the defense claim are part of this group, connected to a pagan Nordic religion that has been linked to various white supremacy groups in the area. Now, the prosecutors have argued that the theory holds little water and relies nothing more on speculation, hearsay, and a lack of specific evidence being produced, tying a third-party perpetrator to the killings. This led to the prosecutors filing this motion in limine, requesting that the court prohibit the defense from including the Odinism theory in the defense. Now, the court eventually, not shockingly, sided with the prosecution, though she left open the door for the defense to present their theories of actual proof if they could actually be brought forward. You have to have a little bit more than speculation, and that's what the court put in her order. It says the case law is quite clear. The nexus must not be based on speculation, conjecture, rumors, or hearsay, but rather on admissible evidence. That's what is being appealed in the interlocutory appeal. Now, interlocutory appeals are discretionary, which means the court does not have to take them, and they can say, we'll hear it if there's an appeal and after there's a conviction in the lower court. I'd be a little surprised if the court the appellate courts took this issue up right now. They usually like to wait until the full record has been developed. Now, one thing that should be a crime and is possibly punishable by being removed from the bench, I'm just kidding, was Judge Gull's order. It was the most pathetic thing that I've seen in a long time in such a serious case. Normally, and we've seen orders from various judges, for example, in Idaho, that give very detailed explanations as to what the issue is, the law, and the analysis as how the judge came to that conclusion. Judge Gull's argument or order looked like it was basically written by, an 8th grader. It was not very well reasoned, and that may be some basis where the court could say this record is insufficient. Let's go ahead and have a hearing on it. I don't know. Pretty unlikely. The defense, in my humble opinion, I've said this before and I'll say it again, should have saved all of their thunder for trial, and going into all this stuff, tipped off the prosecution early. Prosecution countered with a motion in limine, and the judge says you can't do it. Now, understand, ladies and gentlemen, alternate theory is you have to say, to be able to go into court and accuse somebody of doing something, you have to have a little bit of proof to it. You have to be able to say, this person did it. They were at the location or near it at that time. They had kind of a motive to do so. And it's plausible that they could have done it. There's something maybe linking them to it. Like maybe the previous guy always left a card or a flower at the scene. And this one, there was a card or a flower at the scene. And this guy just happens to live 2 blocks away, and he's previously been convicted of the same thing. That would be a legitimate alternate suspect theory, not just saying, hey, a bunch of these kind of weird dudes that believe in some weird stuff that we think, little X's and O's on trees are similar enough because it's kind of weird to them. So they probably did it. Yeah, not coming in if the judge has anything to say about it. And it would have been a heck of a lot better to hold your cards close to the vest, bring it out at trial, and then make the judge shut you down in front of the jury so it looks like you're not receiving a fair trial. And then you still try to squeak it in. That's what I would have done. I'm telling you, ladies and gentlemen, how many times have I said this? This is where everyone gets wrapped around the axles, as do attorneys. They think that you're going to win on some great legal issue in criminal law. Yeah, maybe if there's a motion to suppress, sure, you get some items suppressed. Maybe you get a statement suppressed. But it still comes down to facts. Facts, facts, facts. And just like in this case, you need facts to be able to prove your theory. Doesn't matter what you think. It doesn't matter what you believe. It only matters what you can prove. And that goes for the defense as well. That's why I think some people get so upset with me, because they come up with all these theories on all these different cases, and I kind of put a kibosh to it and say, that's great, but how are you going to prove it? Well, I don't know. It's possible. Okay, it's possible that, I'm going to get hit by a huge meteor before this video is done. But is it likely? No. Is it provable? No. So just something to think about, ladies and gentlemen. Sorry to be the party pooper. Just bring it to you straight. Next, the Tryreek Hill video. If you haven't seen this video, it's probably the best 3 minutes of your time. Now, the question becomes, should Mr. Hill have simply complied by rolling down his window? Or maybe the police officer overreacted just a wee bit. So, if you haven't seen the video that's been released, it shows the moments that Tryreek Hill goes flying by the Miami police before he was pulled over and ultimately put to the ground by the officers on Sunday morning as he was making his way to the football stadium where he was headed in his fancy sports car because he is a Miami Dolphins professional football player, a wide receiver to be specific. Anyway, he was handcuffed by police in dramatic scenes after citing 2 traffic violations while making his way to the Hard Rock Stadium for the season opener. Well, the video shows the 30-year-old being handcuffed and restrained on the ground after he was stopped for speeding, while one of the officers appears to strike him on the sidewalk. Now, one of the officers involved in the incident has been placed on administrative leave amid an investigation, and the Miami-Dade Police Department is the one who's actually released the video. Now, at the start of the footage, Hill can be seen speeding past the police officer who pulled him over. Now, the NFL star flies down the road in the back of his car to alert the officer's attention before he's asked to pull over. After doing so, the altercation begins when Mr. Hill seemingly refuses to wind down his window. Now, after doing so, the altercation begins when Mr. Hill refuses to roll down his window when instructed to do so by the police. Now, the police initially approached his car before he appeared to hand over his license while telling the police officer, "Do what you gotta do." Hill then put his window up, which prompted officers to tap on the car window saying, "Keep that window down. Keep your window down, or I'm going to get you out of the car. As a matter of fact, get out of the car," one officer told him before another warned the football player, "Will break the freaking window." Hill was cited for reckless driving and driving without a license. Take a look. It's only 3 minutes, ladies and gentlemen. We put it up last night. I did it myself. I must say so myself. Probably why it hasn't got that many views. But anyway, I did it myself. So really the question is, should he just complied? Wouldn't have been a big deal? Yeah, probably. Do you have to leave your window down? No. Do you have to comply with all the officer's requests? No. But there's an easy way and there's a hard way. You're going to get your ticket. Just take it. But the cop, he didn't have to. None of the cops had to overreact the way they did, in my humble opinion, for whatever it's worth, ladies and gentlemen. I probably would have left my window down. Tried to sweet talk my way out of it. I'm sorry, officer. What a great day. I'm sorry. I was just so excited. I was listening to the music. I was getting ready to go play a professional football game. Oh, did I mention I'm a member of the Miami Dolphins? Do you want to be the guy responsible for us losing our first game because I got arrested? There's an easy way and there's a hard way, ladies and gentlemen. Everybody always picks the hard way. I just don't get it. Next, this is what happens when you get a little vigilante justice. So a Wyoming man, get the facts of this case. A Wyoming man who rescued a 14-year-old girl from a sexual abuser was sentenced to 10 years in prison for kidnapping him, while the pedophile received a similar sentence of between 10 and 14 years. So back in April, Timothy Ott pled guilty to kidnapping Zachary Menard. He was 23 when he was found in bed with a 14-year-old girl by her mother. The woman contacted her boyfriend, Mr. Ott, who rushed over to the house with the 35-year-old friend in tow. The 31-year-old confronted the abuser, and soon a pretty good fight broke out, during which the young girl vomited, according to reports. And while the friend repeatedly kicked Mr. Menard, Ott took the then 22-year-old by the ankles and dragged him outside. Now, after letting the abuser get to his feet, they ordered him into the trunk of a 2000 Chevy car, which he promptly did. Menard claimed to police that Mr. Ott deliberately drove him in an erratic manner so that he would be thrown around against hard metal objects while in the trunk. It sounds like a scene from Yellowstone. Anyway, the abuser thought that he was being taken to some remote location where they were going to kill him. I'm not saying they should have, but if he'd wound up missing and no one knew where he went, and Mr. Ott probably wouldn't be going to prison. I'm just joking. Anyway, eventually, the car came to a stop. Mr. Ott stopped the car, got out, punched Mr. Menard multiple times, breaking his nose. The two men then left the 22-year-old out in the middle of the Wyoming countryside, where the temperature was about 35 degrees. Now, before driving away with his friend, Mr. Ott told Mr. Menard to walk back to town and think about what he had done. Well, the next day, Mr. Ott returned to the scene to look for the abuser, fearful that something might have happened to him because he hadn't heard from him. Anyway, Ott learned that Mr. Menard had already been found and was now being treated at a hospital. Well, the kidnapper, Mr. Ott, spoke with the police, confessed to his crime, and expressed great regret that things went maybe just a little too far. Only a few days after his arrest, police found paraphernalia with a trace amount of meth in Mr. Ott's possession as well. Probably needed that to get a little pumped up for the situation. Anyway, the judge gave Ott a 3 to 5 year prison sentence for the drugs, but allowed him to serve it concurrently with the time frame for the kidnapping. Now, Mr. Menard also admitted to having sex with the underage girl. So guess what? He's going to prison too. And he's going to pay $3,000 in fines, $500 in restitution, and the judge has ordered him to be a registered sex offender. 23-year-olds can't have sex with 14-year-olds, ladies and gentlemen. That's illegal. Well, he's going to prison for 5 to 10. There you go. What can you do about that? Next, a police dog dies and his handler has been charged. And his handler is Lieutenant Daniel Ziegler, and he is charged with 1 count of misdemeanor animal abuse following an investigation by the Missouri State Highway Patrol after they conducted their investigation and filed a probable cause affidavit to have the prosecuting attorney approve it and have the lieutenant arrested and charged. It is alleged that on the evening of June 20th, a neighbor saw the deceased police dog in the yard by the vehicle and later told investigators that Lieutenant Ziegler was flipping out. They described Lieutenant Ziegler as being distraught and yelling in disbelief, claiming he thought he had brought the canine in at the end of his shift. Well, anyway, soon after that, the police chief drove to the lieutenant's home, where witnesses say he heard the lieutenant tell the police chief that the canine's death was his fault. Now, the temperature at the Kansas City International Airport, the nearest weather reporting station, which is about 50 miles away from Savannah, Missouri, recorded a high of 88 degrees on that June afternoon. 6 days later, investigators conducted a functionality test of the Savannah, Missouri police canine vehicle that the lieutenant had in his possession, and in that testing process, investigators parked the vehicle outside in direct sunlight with the ignition off. It was designed to turn on when the internal temperature of the vehicle shot up to 90 degrees Fahrenheit. The vehicle's horn blared repeatedly with an alarm, the rear window rolled down, and a fan is activated. The test demonstrated that the ACE canine system inside the Savannah police vehicle was in good working order and that it had been manually turned off on June 20th, 2024. Anyway, the deactivation of that ACE canine system directly contributed to the death of the canine Horace by removing the safeguards to prevent such an incident. Feel sorry for the dog, obviously. You know, those handlers are usually pretty close with their dogs, so I'm sure it was a tough day for him as well. Just goes show we can all make mistakes now, can't we? Sometimes they're deadly. Next on the docket, this day in legal history, September 10th, the Luzerne County Sheriff and deputies opened fire on a group of 400 striking minors in the town of Latimer, Pennsylvania on September 10th, 1897. 19 strikers were killed and 39 were injured. Now, the Luzerne County Sheriff, James Martin, and his deputies were later acquitted. Ultimately, the Luzerne County Sheriff, James Martin, and his deputies were charged but later acquitted by a jury after claiming that the strikers advanced upon the police. Self-defense, obviously. September 10th, 1977. A guy by the name of Hamida, D-J-A-N-D-O-U-B-I, Jandubi. Let me know. Tell me how bad I mispronounced the pronunciation of it. Anyway, he was a Tunisian immigrant convicted of murder in France, and he became the last person executed by the guillotine. The French death penalty was formally abolished by the then President Francois Mitterrand in 1981. And yes, on this day, on September 10th, 1991, the Senate Judiciary Committee opened hearings on the nominations of Clarence Thomas to the United States Supreme Court. The proceedings would become a watershed moment in the discussion of sexual harassment when Anita Hill, a law professor who had previously worked under Clarence Thomas, came forward with allegations against him. Well, Clarence Thomas is still on the court. The chairman of the Judiciary Committee was then Senator Biden. I'm not sure he recalls the hearing, but guess what? Clarence Thomas is still on the Supreme Court, and Biden's not going to be president much longer because he'll be out of office. But at least Clarence Thomas remembers what the hearing was about. Just saying. And finally, our dumb criminal of the day. Meet Benjamin Koenig. We'll give him the presumption of innocence like we do everybody, not just our dumb criminals. Anyway, he was traveling on American Airlines Flight 173 from Milwaukee to Dallas last Tuesday when he was told to put down his vape pen. And you know where this is leading. That's right. He became irate. After several attempts to calm Mr. Koenig down, the flight had to be diverted to Tulsa, Oklahoma, where the passenger was ordered off the plane and charged with public intoxication and obstruction of a police officer. Now, that was the state charges. Wait till the feds get a hold of him, and pretty soon he will be charged with disruption of a flight crew, which carries up to 10 years in prison, 20 if there's certain aggravating circumstances. Now, witnesses allege that Mr. Koenig appeared to be drunk when he boarded the plane and had been seen boozing at the airport since about 5:30 in the afternoon. Now, during the boarding, he was kicking the ankle of an elderly Asian man who was passing by when he demanded a pre-flight drink from the flight attendants. And then once they took off, Mr. Koenig retrieved a vape pen from his pocket and began using the device, only to react furiously when told to stop. He also continued to vape after being told to stop by the flight attendant when she went to speak with the captain about his behavior. He berated the flight attendant so much that she began to cry and was shaking. Passengers forced Mr. Koenig back into his seat, whereupon he began to make a series of threats and homophobic insults. That's one way to endear those witnesses to you, that's for sure. Anyway, ultimately, the second flight attendant on the plane said, guess what? We're going to divert to a different area because Mr. Koenig was causing such a commotion. And when he got off the plane with his suitcase, let me tell you, he was quite upset. Like I said, he was cuffed and booked into the Tulsa County Jail and was released after paying a bond. But he has one count of public intoxication and obstruction. Just another example why you got to hate commercial air travel these days. The Mr. Koenigs of the world, it's a 3-hour flight. Nobody can behave themselves for 3 hours. Are you kidding me? 3 hours, ladies and gentlemen, to not drink, not smoke, not use profanity. 3 hours, ladies and gentlemen, and Mr. Koenig couldn't do it. Now, we'll give him the presumption of innocence, but guess what? He is our dumb criminal of the day. Congratulations. You're an idiot. All right, that's all we have for you today. Quick reminder, no live tonight. We'll do it tomorrow night, 6 p.m. Mountain Time. Have a wonderful day. Remember, the Constitution matters.